Welcome back to LexTalks, Legal Eagles. Ready for another deep dive into the intricacies of Indian law?
Always up for a legal challenge.
Today we are tackling a concept that can be a real brain twister for law students.
Oh, I know the one you mean. Sounds simple at first, but then it's like, wait, what?
Exactly. The Doctrine of Election under the Transfer of Property Act of 1882.
Ah, yes, the classic, you can't have your cake and eat it too principle.
Exactly. It's all about those tough choices.
Mhm.
Like, imagine someone offering you, I don't know, a brand new scooter, but to get it, you have to give up some of your land.
Ooh, tricky. That's a great way to put it. You can't accept a benefit from a transfer and then turn around and reject the parts you don't like.
So let's break it down. What exactly does this doctrine mean in the legal world?
Well, in simple terms, if someone tries to transfer property they don't own, but as part of the deal, they offer a benefit to the owner has to make a choice.
So they can either take the benefit and go along with the transfer, even if it means losing some of their own property, or,
Or they can say, no thanks, I'll keep what's mine, and reject the benefit. It's all about balancing the rights of the person making the transfer and the person receiving the benefit.
it's like a legal tug of war, making sure things are fair on both sides.
Exactly. Now, to get into the nitty-gritty, we need to look at Section 35 of the Transfer of Property Act.
Ah, the legal rule book. So what does Section 35 tell us?
It lays out two main conditions for the Doctrine of Election to apply. First, someone's trying to transfer property they have no right to. Second, they're offering a benefit to the rightful owner, but it has to be part of the same deal, no separate agreements.
Got it. No sneaky side deals. Now, are there any exceptions? Like, when would someone not have to make this choice?
Great question. If the benefit you get is indirect, meaning it's not directly tied to that specific property transfer, you're in the clear. You don't have to elect.
Okay, so if the benefit would have happened anyway, regardless of the property situation, no election needed. Makes sense. What about the people involved? Do they matter?
Absolutely. The person transferring the property and the one getting the benefit must be the same person acting in the same role.
So no switching hats trying to take advantage of the situation.
Exactly. It has to be a genuine attempt at a transfer, even if it's a bit messy.
So we got the basics down. But how does someone actually elect? Do they just shout it from the rooftops?
Uh-huh. Well, it can be that simple. You can definitely make a clear statement saying, I accept, or, no way, Jose.
Straight to the point. But what if they don't say anything? Is that allowed?
Silence can be tricky. The law gives you 2 whole years to make your choice.
2 years. Wow. That's a lot of time to mull it over.
It is. But if you stay silent for those 2 years, it's like you've said yes by default. It's an implied confirmation.
So even if you don't say anything, you're still making a choice. Interesting.
Exactly. And to keep things moving, after 1 year, the person who made the transfer can actually give you a little nudge.
Like a legal, hey, you're going to decide or what?
Exactly. And if you still don't respond after a reasonable time, well, it's taken as confirmation. You've essentially accepted the deal by not saying no.
So while you have 2 years to decide, it's best not to play the waiting game for too long. Now, let's switch gears for a second and talk about the person on the other side of this whole transfer. What happens to them if the owner decides to keep their property?
Yes. The disappointed transferee. Imagine this. A grandmother wants to give her vintage record collection to her granddaughter, but she accidentally includes a piece of land in the will that actually belongs to her son.
Oh no. So the granddaughter's all excited about the records, but then,
But then the son, who actually owns the land, decides he wants to keep it. That makes the granddaughter the disappointed transferee.
so she's left with nothing. That doesn't seem fair.
Don't worry, Indian law has a safety net. If the original transfer was a gift and the person who made it is no longer around, the disappointed transferee gets compensation from their estate.
Okay, so if it was out of generosity, not a business deal, the disappointed transferee doesn't walk away empty-handed.
Yeah.
But what if money was involved?
Good question. If the transfer was for consideration, meaning something of value was exchanged, the transfer or their representative has to compensate the disappointed transferee regardless of whether they're still alive.
So someone is definitely making things right, whether it's the original person or someone representing them. That makes sense. It keeps things fair for everyone.
Exactly. And here's a fun fact. This is actually different from English law, where the owner who keeps the property is responsible for compensation, not the person who tried to transfer it.
Oh, wow. So different legal systems, different approaches. It's fascinating how these things vary.
Absolutely. It shows how the law is shaped by different cultures and traditions.
Well, folks, we've covered a lot of ground in part 1 of our deep dive into the doctrine of election. but we're just getting started.
Stay tuned because in part 2, we'll be tackling some real-world scenarios that'll really put your knowledge to the test.
It'll be like a legal puzzle, using the doctrine of election to unlock the solutions. Get ready to stretch those legal muscles. Welcome back to LexTalks, ready to untangle some more legal knots.
Always. I love a good legal puzzle.
We'll get those thinking caps on because in part 2, we are putting that doctrine of election knowledge to work.
All right, bring on the scenarios.
Okay, first up, imagine a grandfather, let's call him Mr. Kapoor, who wants to pass down his treasured stamp collection to his grandson, Arav. But here's the twist. Mr. Kapoor thinks he owns a small orchard that actually belongs to his daughter, Anjali. In his will, he leaves both the stamps and the orchard to Arav. What happens next?
Classic doctrine of election right there. Anjali, the rightful owner of the orchard, is being offered a benefit, that awesome stamp collection, as part of a transfer that also tries to dispose of her property, so she's got a choice to make.
Accept the stamps and essentially wave goodbye to the orchard,
Or keep her orchard and say no thanks to those rare stamps. It's a tough call, isn't it? But it's all about weighing the value of each option. Is that orchard in a prime location? Does it hold a sentimental value? Could it be worth more in the future? She needs to consider all the angles.
it's like a legal balancing act, weighing the pros and cons of each path.
Exactly. It's not just about the immediate gains, but the long-term implications as well. Okay, ready for another scenario?
Hey, wait a minute.
Let's say we have a couple going through a divorce. Neha and Raj, they own a beautiful houseboat together. Raj wants to give his share of the houseboat to their daughter, Anya, but he also throws in a vintage camera that actually belongs to Neha. Does this ring any doctrine of election bells?
Let me think. We've got a property transfer where Raj only owns part of it, and he's offering a benefit, that vintage camera, directly to Neha, the actual owner of the camera, as part of the deal. Sounds like a textbook case to me.
You nailed it. Now, imagine Neha's dilemma. That camera might be a family heirloom, something irreplaceable. But giving it up means losing her claim to that houseboat, which could hold sentimental value or even financial potential. Plus, there's the whole emotional baggage of a divorce. Tough situation, right?
Absolutely. It's not just about the objects themselves, but the memories and emotions tied to them.
Precisely. In these situations, it's crucial to have a lawyer who can guide you through the legal maze and also understand the personal stakes involved. Okay, one final scenario to really test your understanding. Imagine 3 siblings, Aditya, Maya, and Vijay, who inherit their family's ancestral home. Aditya decides to transfer his share of the house to Maya, but he includes a rare book collection in the deal. Now, this book collection actually belongs to Vijay. It's a collection their father spent years building, and it means the world to Vijay. What does the doctrine of election have to say about this situation?
This one really tugs at the heartstrings. Vijay is faced with an incredibly difficult decision. Choose the book collection and lose his part of the ancestral home, a place filled with family history and memories, or keep his share of the property and let go of those precious books that hold so much sentimental value.
You've captured the essence of the dilemma perfectly. The doctrine of election doesn't provide easy answers. It's about giving individuals the power to make choices that align with their own priorities, even if those choices are incredibly tough.
It's a reminder that property law isn't just about legalities. It's about people, their relationships, and the things they hold dear.
Well said. The law provides the framework, but it's ultimately up to the individuals involved to decide what matters most to them.
And that brings us to the end of part 2 of our Doctrine of Election deep dive. We've explored some real-life scenarios, highlighting the complexities and emotional layers that often come into play.
Remember, the doctrine of election is all about balance and informed choices. It's about making sure that no one is unjustly benefiting while also respecting individual rights and preferences.
Stick around for part 3, where we'll be diving into some fascinating real-life cases that showcase the Doctrine of Election in action. Welcome back to LexTalks. Are you ready to see how the Doctrine of Election plays out in the real world?
Absolutely. Let's delve into some fascinating legal battles that illustrate the complexities of this concept.
I'm all ears. Let's start with a case that went all the way to the Privy Council, the highest court of appeal for India back in the day. It involved a Hindu family and a will that left some property to a temple.
Oh, this sounds intriguing. Was there a dispute over the ownership of the property?
You bet. The will tried to give away property that actually belonged to one of the family members. And guess what? The Privy Council stepped in and applied the Doctrine of Election.
Wow. So even back then, this doctrine was being used to resolve these kinds of property disputes. What was the outcome of the case?
The court basically said, look, You can't have it both ways. If you want to benefit from the will, you have to accept the whole thing, including the parts that might not be in your favor.
So they had to choose between keeping their property and giving up the benefits outlined in the will. Tough choice.
It really highlights how the doctrine of election forces people to make difficult decisions, especially when family ties and inheritance are involved. Now let's fast forward a bit to a case from 1916. This one involved a Muslim family, and again, there was a will that created quite a stir.
A will causing a stir sounds like my kind of legal drama. What happened?
Well, in this case, the will tried to give away property that belonged to someone outside the family. And to complicate things, the will also offered a benefit to the actual owner of that property.
Classic doctrine of election setup. So did the Privy Council step in again?
They sure did. And once again, they applied the doctrine of election, emphasizing that it applied equally to both Hindu and Muslim law. It reinforced the idea that this doctrine is a fundamental legal principle, not limited to any specific religious or cultural context.
That's fascinating. It shows how legal principles can transcend boundaries and provide a framework for resolving disputes across diverse communities. These cases really bring the doctrine of election to life, don't they?
They do. They show us how this concept isn't just some abstract legal theory. It has real-world consequences, shaping people's lives and the fate of their property. And it's a concept that's still relevant today, centuries after these landmark cases were decided. So whether you're a law student, a legal professional, or simply someone who enjoys unraveling the complexities of the law, remember this. The doctrine of election isn't just about rules and regulations. It's about balancing competing interests, protecting individual rights, and ensuring fairness when it comes to property transfers.
Well said. It's a reminder that the law is a living, breathing entity, constantly evolving to meet the challenges of our ever-changing world. And who knows? Maybe one day one of our listeners will be involved in a case that redefines the doctrine of election for future generations of legal minds.
That's a great thought. It's a reminder that the law is a dynamic field, and there's always room for new interpretations and perspectives. Well, folks, that brings us to the end of our deep dive into the doctrine of election. We've explored the legal foundations, analyzed hypothetical scenarios, and even examined real-world cases that showcase the practical implications of this fascinating concept.
We hope you've enjoyed this journey into the intricacies of Indian property law.
And remember, if you ever find yourself facing a property dilemma that seems like a legal puzzle, don't hesitate to seek expert advice. There are skilled professionals out there who can guide you through the maze and help you make informed choices that protect your interests. Thanks for tuning in to LexTalks. Keep those legal minds sharp, and we'll catch you on our next deep dive into the world of law.